The matter before the court this morning is PUC 24310, Consolidated Communications of Northern New England versus the Public Utilities Commission et al. For everything. We are being recorded and streamed live on the web, both by video and by audio. I would ask counsel who would be arguing to introduce themselves, say the names and the party that they represent for the record, starting with the appellant.
Thank you, Madam Chief Justice and members of the court. Good morning. My name is Bill Hewitt with the law firm of Hewitt & Hewitt. Accompanying with me at counsel's table is Andrea Hewitt, and together we represent Consolidated Communications as the appellants in this appeal.
Thank you.
May it please the court.
Let's get introductions from everybody first. I'm sorry.
That's fine.
And for the appellees.
Jordan McColeman.
Okay.
Good morning, Assistant Attorney General Kimberly Pat Warden on behalf of the Attorney General.
Thank you. And it's my understanding that we're going to be a little fluid on how the 15 minutes gets allocated for the appellees. Is that correct?
Thank you very much.
Okay. Mr. Hewitt, I would be happy to hear your argument at this point.
Very eager today, Your Honor.
I appreciate that. Thank you.
May it please the court. Before the court is an order of the Public Utilities Commission issued pursuant to Section 2524 of the Public Utility Code and Chapter 880 of the Commission's administrative regulations. The Commission's order prohibits Consolidated Communications from charging the town of Somerville for make-ready work. Consolidated's make-ready work, totaling nearly $100,000, is necessary to make room for the town's competing broadband attachments on about 600 joint-use utility poles located in Somerville and adjoining towns. The municipal exemption enacted in Section 2524(2)B in Chapter 880, Section 6A1 of the Commission's rules is unconstitutional because the exemption prevents Consolidated from receiving just compensation for the physical occupation of its private property, and the exemption also violates equal protection. As for the takings claim, the law is well settled. The government-authorized physical occupation of private property is a per se taking. In Gulf Power, the 11th Circuit concluded that pole attachments are a physical taking per se. And under the Supreme Court's precedent on physical takings, bookended by Loretto and more recently Cedar Point Nursery, the court has recognized that the right to exclude others from private property is one of the most treasured rights of property ownership. In Cedar Point, after examining the court's line of cases on physical takings, the court summarized. The upshot of this line of precedent is that the government-authorized invasions of property, whether by plane, boat, cable, or beachcomber, are physical takings requiring just compensation. To be lawful, physical occupations must be accompanied by just compensation. And in the utility pole context, which has been litigated extensively before the FCC, reviewed by the 11th Circuit, reviewed by the Supreme Court, under those lines of cases and under those reviews, the FCC's formula has been approved, and that formulation has two important components of just compensation. One is the make-ready charges that are before the court today. The other is the annual rent. Now, under the Commission's Chapter 880 rules, in Section 4, annual rent is determined by adopting the FCC's so-called cable rate formula. And in Section 6A of the Commission's rules, which governs separate charges, they clearly state that a pole owner is required to charge the attacher for make-ready, except when prohibited by the municipal exception.
Counsel, I see that the green light is on. Can I, let me go still on this takings issue. We have from the U.S. Supreme Court the New Orleans case as well as the Maine cases that talk about the fact that utilities may be required to move, for example, poles or other conduits, correct, without compensation.
That's correct, Your Honor,
All
under the
right.
common law.
On the other hand, we also have Loretto, which says that it is a taking to have the cable company occupy the private residence, essentially, without compensation, correct?
Correct.
All right. So the question is, where's the through line between those, right? In Loretto, there was no compensation, is that right?
The compensation that was awarded was $1,
Okay,
which I
but
believe...
there was no just compensation.
Correct.
For the permanent occupation that they referenced, correct?
That's correct.
And in Gulf Power, they said it was a taking because it's a permanent occupation, and that's factually more obviously similar to what we have here, but that it wasn't an unlawful taking because there was a just compensation route, correct?
I believe the holding was there was an opportunity to enforce...
That's why I said just compensation route. I think it was not really, they weren't passing on whether the amount of the compensation was correct.
I agree with that assessment, yes.
So do you agree that in Gulf Power, they were looking at both the make-ready costs and the ongoing rent as one? In other words, they didn't really distinguish between those things.
Well, whether Gulf Power did or not, if you look at the large body of law, including the FCC decisions, the other 11th Circuit decisions, those all are very clear, including, and we've cited them in the briefs, but if you look, for example, at the Atlanta cable decision at the FCC, which was then affirmed by the 11th Circuit on appeal, those decisions are very, very clear that there are these two components of compensation. It's both the make-ready in order to allow for the
ongoing rent.
And the ongoing rent.
Okay. Bear with me for a moment.
Certainly.
So there's no question that you are entitled to ongoing rent in this case, correct?
Yes.
And isn't that the compensation for the ongoing physical occupation?
It is. That is intended to compensate the pole owner
For the ongoing physical occupation.
That's correct. But
So now we've got the make-ready costs. And aren't the make-ready costs by themselves, because of the compensation for ongoing physical occupation, more similar to the requirement that utilities may be required to move or adjust conduit and poles without compensation?
not at all.
Why?
Because it's blurring the line between the line of cases that address public utility location within a public right-of-way. Those are the cases that the Attorney General cites, and they spent a lot of time on those. That's one body of law. There's an entirely separate body of law that relates to the physical occupation of the pole.
There is, and so my question is, how do we make those two things?
Well,
where is the dividing line? When is it one and not the other?
Well, the dividing line is when there's a decision that is made to actually occupy private property. All the cases that the state cites, those come out of common law. And we acknowledge that whether it's a utility pole, whether it's a water pipe, whether it's a gas main, all public utility infrastructure has historically only held a license to occupy the right-of-way. It's up to the towns to decide where in the right-of-way those are located. But the towns have never had the authorization under the Public Utility Code or common law to actually occupy the utilities infrastructure. That has always been and always will be private property.
And I appreciate that, and that's why I was distinguishing, though, the make-ready cost is different than the ongoing occupation for which you are entitled to have compensation.
But it's all part of just compensation. If you look at the facts of this case, Your Honor, it's very clear. The Consolidated's make-ready charges are nearly tickling $100,000. The rent they will charge, on an annual basis no less, is about $1,100. So the amount of rent is in no way going to compensate them for the significant
So
expense.
it looks like the amount of rent is sufficient, however, to compensate for, or at least you've not raised a question about whether it's sufficient to compensate for the ongoing occupation, which is the very nature of what the taking is.
That's correct, but unless you go through the make-ready process, there isn't going to be room on the pole for the attachment. They're part and parcel, inseparable. And if you look at the FCC's decisions and the 11th Circuit opinions that confirm those decisions, there is no question that both of those elements are required in order for there to be just compensation.
Is the hinge of your argument that the make-ready costs are part of the takings concept that you're floating here?
Definitely.
So if we decide no, that they're not, does the rest of your argument fail?
Well,
That they're sui generis to be treated
The
independently?
takings argument, not
The
necessarily.
takings
other
argument, yeah.
so I'm sorry, Justice Mead, I'm not understanding your question.
Okay, if you say right now the make-ready charges are takings. It falls under the umbrella of takings?
The statute at issue, the sole purpose of the statute at issue is to excuse municipalities from having to pay a necessary component of just compensation in order to support broadband development.
Just as they're excluded from having to pay relocation costs. So why can't the make-ready charge be justified as simply a cost of occupying the public way?
Because it is a physical occupation of private property. Public utility property, although it's in the public way, is private property. And so if the state wants to occupy the private property, it's a per se taking.
If the state wants to occupy the private property, they have to pay monthly rent, which they will have to do.
But for, and there's no argument about this in the record, but for the make-ready, which is necessary in order to assure not only that there's room on the pole, but that the safety regulations that govern where attachments are located on poles, which is governed by the NEC, the National Electric Code, Telecordia Blue Book, in order to comply with those safety regulations, make-ready is absolutely necessary in order to make room for the attachment. Or it could be that a pole completely needs to be changed out because there isn't sufficient room.
Well, historically, wasn't the municipality or the governmental entity relieved of having to pay the make-ready fees in the context of engaging in public exercise of the police power of the state?
There may have been times in our past where pole owners were vertically integrated utilities that provided comprehensive services. They had monopolies on the territories that they served, and as part of the regulatory bargain, their rates were regulated based on cost of service principles. So 30 years ago, there was probably not a lot of attention paid to make-ready costs that may have been foregone because the utility had an opportunity to recover those through the rate-making process. And today, Central Maine Power Company, Versant Power, the T&D utilities that are also owners of poles in the state, they have a similar opportunity. They would continue to have that opportunity to recover those costs that they would otherwise
Well,
forego.
you have the opportunity to recover your costs. You're just making a business decision that you may not want to recover those costs from your customers
May I
because of the competitive issue. And yes, you may.
May I respond to that?
Yes.
Consider, for example, Your Honor, the city of Portland decides that it wants to deal with its housing crisis or its homeless crisis, and what it does is it enacts an ordinance that says if you're a motel, you have to allow us to use 50% of your rooms to house the homeless. And we're going to occupy those rooms and allow the homeless to stay there. Well, we're not going to pay you any compensation for that because you've got 25 other rooms that you can use. Just double the rent on those. That's not how takings work. It's the government's obligation to pay for what it takes. It is
But
not
it
the
does
private.
go to the other argument you made on equal protection. I see our time is up, so you'll have some time for rebuttal.
Thank you.
Counsel?
Good morning, Your Honor, and may it please the court. The Public Utilities Commission did not make any findings regarding the constitutionality of the municipal exemption. Having said that, I am happy to address any questions that the court may have for the PUC on.
Well, then let's just follow up with where I was. Where is the through line with the New Orleans case from the U.S. Supreme Court, the Maine Turnpike Authority case, and Waterville Renewal? I'm saying them wrong, but you know which cases I mean here in Maine. On the one hand, that says they can be made to relocate pipes, conduit, et cetera, and yet a physical occupation is clearly a taking under Loretto, under the Gulf Power case, and under the other takings cases. Where is the through line here? Why is this not a taking?
So, Your Honor,
I mean, they're not relocating conduit and poles. The poles are being occupied.
correct, Your Honor. I hesitate to opine, as it would just be me standing here opining, as the Public Utilities Commission did not address or analyze the constitutionality, the takings issue.
Oh, if you
in
want
this
to
case.
cede it to co-counsel, you can.
Well, yes, Your Honor, and that was my purpose for getting up, was if the court had any other questions for the commission on the other issues that were raised, I'm happy to address them. If not, I am more than happy to cede to co-counsel.
I have a question about the ongoing rent that's paid. Is that negotiated on a regular basis, and is there an opportunity for a pole owner like this appellant to renegotiate the rent that's paid on an annual basis to try to recoup some of these additional costs?
So that's an interesting question, Your Honor. So the answer is yes, but. So pole attachment rates are subject to arm's length negotiations between attachers and pole owners. However, the Commission's rules and also the federal rules contain what is essentially a backstop, that is a calculated formula that will arrive at a just rate that will be applied in the context of a dispute between the parties. So if the parties in arm's length negotiations decide on $10 per pole per year and everybody's happy with that, then that's what gets paid.
So if Consolidated came in at the next opportunity and said, we'd like to raise the rent, X dollars to help us recoup some of these costs, that's an item that could be negotiated?
It could be negotiated not with the Commission, Your Honor, it can be negotiated with the other party. If there was a dispute, if there was an impasse between the parties and they came to the Commission would apply a mathematical formula to come up with the rate.
Does that formula cover or include any portion for make-ready work?
My understanding, Your Honor, is that it does not specifically do that. It's based on accounting data that's within the utilities books. And again, it's just a mathematical formula, but I don't think it calls out make-ready specifically, Your Honor.
Thank you.
Thank you very much.
Okay. Counsel,
Good morning, and may it please the court.
shall I restate my question?
Sure.
I'm still looking through the through line with the New Orleans gas case from the U.S. Supreme Court, the First National Bank versus Maine Turnpike Authority, the Waterville Renewal, all those cases that say a utility can be made to move or relocate out without any compensation, on the one hand. And on the other hand, the cases that say a physical occupation is indeed a taking. And in this case, how is there not a physical occupation of the poles? What is the through line with the cases on the one side with New Orleans, et cetera, and Loretto, Gulf Power, and the other related cases on the other hand?
So I think the through line or the distinction is between, very simply, the amounts paid to occupy the poles, which is the required rental rate that the town of Somerville will be paying to Consolidated, and the distinction between the costs that are required to move the poles or lines or wires in the public way in order to accommodate that use by the municipality. In other words, the state does not affect a taking when it requires utilities to move at their own expense wires and poles that are located in the public way in order to accommodate other public uses. As Chief Justice Stanfield pointed out, that's been the case since 1905, when underground gas lines in the public way had to be moved to accommodate a drainage system in New Orleans. So the Supreme Court said there was no taking and no compensation was required. And this court has followed the Supreme Court's guidance, or the precedent. In 1957, utility pipes, wire lines, other facilities in the public way had to be moved to allow for the extension of the Maine Turnpike Authority.
Has the passage of time affected that principle at all? There was some suggestion that they couldn't have anticipated back in '57 the proliferation of cable and other impediments to the utility lines that were in place at the time.
None of those cases have been overruled, Your Honor. I think that municipalities still rely on those cases when there is public improvement that requires the movement of various poles and wires. There hasn't been recent case law because it just hasn't been an issue, because I think utilities know now that moving poles and wires in the public way is not a taking, and that there's no entitlement to compensation to allow for other uses that are necessary for the public good. And we know that broadband is a public necessity. There's Title 30A, Section 5402, subsection 1A, is a statement of public necessity, and the legislature has found that access to affordable, reliable, high-speed broadband internet is necessary to the general welfare of the public. And so because the use that the use that the town of Somerville is making of the public way is also for the public necessity, just like drainage
Are all
pipes.
poles necessarily in the public way?
I don't think there's any suggestion that any of the poles are not in the public way in this case.
Does that matter? I mean, is it sufficient if they mostly are, even though, I mean, there's no question that there are poles that are on private property. I mean, CMP goes and takes easements all the time, right?
Sure. I don't think that there's any factual findings or distinctions about poles that are in the public way or not in the public way, and I don't think our argument depends on that particular fact.
Well, if there were poles that were on a private way, would that kick in the Loretto case as applying to that circumstance, because it is a private ownership, as was the case in Loretto, which I think was maybe the tipping point on that case there? We're going a little bit afield of what the original arguments were, but I'm just...
Understood, Your Honor. Yeah, I think it could. If there was a pole being utilized by the municipality and it wasn't in the public way, that could change the analysis. But again, I don't think the parties have argued that any amount of the make-ready works is not in the public way, or any amount of the make-ready work isn't accounted for in the poles that are in the public way.
So I may be misunderstanding Attorney Hewitt's argument, and he'll clarify that when he gets back up. But I think I hear him arguing that the pole is in the public way, but the pole is private property. And what you're asking is the private property owner or occupier to move equipment within that very narrow dimension, literally, the pole. Is your counter argument that, well, the whole thing is in the public space, and that whatever the transistors or whatever they are on the top of the pole is basically like the water pipe under the road?
Yes, and that's in part due to the definition of facilities that's in Section 2524 that references back. It includes anything, essentially. It could be poles, wires, guys. That's all included within the definition of facilities and is subject to the municipal exemption. But I think the reason why this makes sense is because Consolidated is in the public way pursuant to a license. It has a license to occupy the way, and that license is subject to further restrictions a municipality or the state may impose. In its reply brief, Consolidated doesn't deny that that's the case.
Let me ask you this. If we have the make-ready cost, which is really the crux of the issue here, and under the current regulatory scheme, there is an ongoing rental for the occupation. If there were not, would that be an unlawful taking?
If there was no rental fee that was being
Correct.
charged for the occupation of private property, yes.
Okay.
So what's the difference between the two?
The difference between the two is the difference that the cases suggest, is that 2524 is a fee-shifting statute. It doesn't authorize the actual occupation of any property of Consolidated or any other poll owner. And we know that's the case because if Section 2524 was repealed, there would still be a mechanism by which municipalities could attach to polls in the public way, and that would be through Section 711.
Are there any cases you're aware of drawing that distinction between the make-ready costs versus the ongoing occupation fee, the rental?
No, it's nice to be at the forefront, Your Honor.
I always like to be unique.
So you're saying there is a distinction, and it makes a difference? Make-ready costs as opposed to the other possibilities?
Yes, I do think it makes a difference, yes.
Is that the key to the case?
The distinction between make-ready costs and rental costs?
Yes.
I mean, it is definitely an important distinction. I don't think we'd be standing here arguing that there's no takings here if there wasn't an amount that was being paid to Consolidated by the town of Somerville for the physical occupation. It's our view that that amount is just compensation, because that's the same amount that another attacher would pay to occupy those polls according to the statutory formula.
Contesting whether that is actually just compensation or not?
I think that counsel for the PUC just suggested an opportunity whereby there could be an opportunity to either renegotiate that amount or to then go to the PUC. But I'm, to be clear, I'm not sure if the backstop amount that was discussed by Attorney McColeman is the amount that is identified in the brief, but that is a process, yes.
Can you think of an instance when a make-ready cost or a rental cost would be imposed without the other also be occurring?
Imposed on whom, Your Honor?
Well, isn't a make-ready cost always associated with a new attachment?
The new attacher, okay.
And isn't a new attachment always subject to a rental cost?
Any party that is going to attach to a poll has to pay some sort of fee to the poll owner for that sort of physical occupation of that property. I think the reason why a municipality doesn't have to pay the make-ready cost, but a private party does, is because of the nature of the interest that Consolidated has in the public way. It is a license, and that license is subject to further restrictions that are enacted by the legislature, and Section 2524, subsection 2, is one of those restrictions. And again, Consolidated hasn't denied that its interest is in the nature of a license and that it is subject to further restrictions that may be enacted. We pointed out in our brief some of the restrictions that are already imposed, which would be to obviously moving items in the public way, if they are necessary for traffic or for safety. There's restrictions on not being able to move certain trees. Again, this is just another restriction that is imposed on licensees in the public way when they are going to utilize that for their commercial purposes. Those have to give way to the municipal authority and the municipal power for the public interest. Otherwise, Consolidated would have a superior interest in the public way than the municipality does.
I think what you said in your brief is that Section 2524 is not really that, the make-ready aspect and the allocation of costs under 2524, is that in and of itself is not the taking. The taking is the ongoing occupation.
That's
and
correct.
So the 2524 is simply a cost allocation.
Correct. It's fee shifting. Yes, Your Honor.
And is any part of your argument that what's going on here as well is sort of rebalancing the allocation of the space in the right-of-way in exchange for covering the make-ready cost?
I think I would maybe flip it, and that the permission to continue to use the right-of-way is subject to this restriction that municipalities must be able to access the impediments in the right-of-way in order to use them for other municipal purposes. And it has to be within the public necessity, but the legislature has declared that broadband is a public necessity. And it's very clear from the town of Somerville why that's the case, right? You know, broadband today is necessary for life. Again, I will stand on our brief on the remainder of the arguments. Thank you for your time.
Counsel. And Attorney Hewitt, you reserve some time for rebuttal.
Thank you, Madam Chief Justice. Fee shifting. This is not fee shifting. If it's doing any fee shifting, it's shifting a constitutionally required element of compensation for occupying private property. There's no fee shifting that's allowed under the Takings Clause of the Constitution.
Is the work involved in the make-ready, is that in and of itself, let's say wires were never thereafter attached, is that in and of itself an occupation of private property?
The make-ready?
Yeah. The work involved in the make-ready, is that an occupation of private property sufficient to amount to a taking if indeed the wires were never thereafter attached?
The occupation cannot happen without make-ready. And to Justice Horton's questions, make-ready is always incurred when there's a new attacher. And where there's a new attacher, the new attacher always has to pay rent and always has to pay the make-ready.
I don't think you answered my question. Is the make-ready work, what's done to the poles by itself, a taking if in fact, and I understand this is not going to happen, but if in fact wires were never attached and it was never used?
The private property owner is required in your hypothetical to expend efforts.
Yeah.
But I suppose there would be no eventual physical occupation. Is there some sort of claim that the utility may have? I don't know, but I would concede that's not the physical taking never occurs. But in this instance, there's absolutely no doubt that the town is going to be competing with Consolidated, competing with other occupants of poles in Somerville to provide a broadband service.
If what the chief has pointed out does not constitute a taking, when does the taking occur?
The taking occurs when there is a physical occupation to the pole. But in order for that physical occupation to happen, the make-ready work has to be done, and those costs have to be. But
isn't there a conceptual distinction between renting property for which compensation is required and getting property ready for rental? In other words, a landlord cleaning an apartment, a rental car company cleaning out a car, they don't expect to get paid for getting the property ready as opposed to renting the property.
That's not a government-mandated occupation of poles. We are not writing from a clean sheet of paper here, right? The FCC, the appellate courts, federal appellate courts, have trod through this in connection with when cable operators were allowed to begin occupying poles. Under the 1996 Telecommunications Act, when competing communications providers were allowed access to the pole. We are not writing from a fresh slate here, as much as the state would like you to think. These issues have all been resolved, and it's very clear under the precedent that there are two elements of compensation, and the state is trying to avoid paying one of them.
Thank you, counsel.
Thank you. Appreciate your time today.
Thank you for the arguments here today. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. With that, we'll be in recess on this matter.
All rise.
The matter before the court is BCD 24-384, Newfield Sand versus the Town of Newfield. We are being streamed live on the web, both by audio and by video. I would ask counsel to identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Kristen Collins for Newfield Sand, the appellant.
Good morning, Ben Plan on behalf of Appellee Town of Newfield.
Thank you. And Attorney Collins, if you wish to make your argument, we'd be happy to hear it.
I do, thank you. Thank you, Chief Justice. Good morning. I don't mean to exaggerate when I say that this case, depending on how it goes, could really upend how those of us who practice municipal and administrative law have always seen the constraints of an administrative board's authority. As you know, a planning board's authority, just like any other administrative agency, is constrained by the express terms of an ordinance. And without those terms, the board cannot act. It is a way that we differentiate the roles of government between administrative, executive, and judicial authority, and enforcement authority in the case of a town. In this case, you had a planning board that apparently felt that it needed to hedge against potential future facts that it didn't know about yet by putting in a condition that essentially took its approval standard, undue adverse impact, and turned it out into the future in perpetuity. If you, the applicant, create through your operations an undue adverse impact, we reserve the right to bring you in before the planning board many years hence, potentially, and change your operating conditions. The conditions here are no small matter for a mineral extraction operation. If it can't be open certain hours, if it can't run a certain number of trucks, it cannot make money. So when you take a standard like undue adverse impact, which is a notoriously squishy standard and a bit subjective, it works at the approval stage because the applicant is working with the board to come up with an operating standard for its operation and make little iterative changes, which this applicant did over a 2-year exhaustive and very expensive process. And it comes to a point of a decision where usually it has objective and measurable standards as conditions by which it has to operate, such as the 70 truck trip standard here. And then the applicant can determine, okay, under these standards, I can proceed with my business. I have reasonable assurance that I can make this business work. When you take this squishy standard and you project it out into the future, that applicant never gets vested rights in its application. It can never rely. And this applicant in particular just told me this morning, it's hesitating to even apply for a loan to get a piece of business equipment because it cannot determine whether in 2 years, 5 years, or 10 years, it's going to be able to continue its operations in a way that is profitable, that it can pay the debt service on that piece of equipment. That is of huge concern to Maine businesses. If this is what boards are permitted to do, to essentially say, we're now going to vest ourselves as judge and jury over this application in perpetuity. And if we decide at some point we don't like it, that is too bad. And it could be because of situations that change.
I see that the green light is on. You
Yes.
just said vest themselves as judge and jury, but didn't the conditions here vest the CEO with the power to bring essentially an enforcement action? And isn't that exactly what CEOs do?
No, and a CEO brings an enforcement action against standards that are in an ordinance that...
Well, there are performance standards in Article 10, Section 7, I think it is.
Yeah, but that's not the standards that were used here. The standards that were used were the approval standards for conditional use, which is that undue adverse impact. So in the normal course, you'd have, and there were mineral extraction standards specific here in Article 10 that are clear objective performance standards that the CEO could bring an enforcement action for, or violations, let's say, of the 70 truck trip limit. That was a clear condition.
Well, let me push back a little on that this is something that towns cannot do. I think somebody mentioned in their brief that if there were a licensing scheme, they could do this, right?
Absolutely, and
So if they have the authority to do it through licensing, Why don't they have the authority to do it under the ordinance?
Well, they're not doing it under the ordinance is the problem. So if you had a licensing scheme, and I gave the example of Augusta that has a permit that expires every 5 years, the difference is that's codified in the ordinance. The applicant goes into that business knowing I've got 5 years, and then I've got to go back and satisfy whatever
So you're saying there
standards again.
can't be a reopener? Let's say there's a permit that is 5 years long. We held in SD Warren that you can have a reopener within a permit, correct?
Well, SD Warren, I went down the Clean Water Act rabbit hole, and it actually specifically calls for conditions going forward to ensure compliance with the state water standards as they may change over time. We don't have that here. It's not in the ordinance because this legislative body could have, in the mineral extraction standards, said, we want ongoing jurisdiction over these things, but it did not do so.
So what you're saying isn't that the town couldn't do it. You're saying that the town didn't do it in its
Regulatory
legislation.
structure, yes.
Where in the ordinance does it outline the powers of the planning board specifically?
The powers of the planning board, I mean, in this case, this is a conditional use application, and I would point you most directly to the conditional use standards, which are in Article 8. And it does say, look, it is a broad standard, and deliberately so, because a conditional use is deemed to be of special concern in terms of its
Is there
impacts.
anything in the ordinance elsewhere that would allocate to the planning board, essentially the enforcement or hearing power
Oh,
over
absolutely not.
violations?
No. Enforcement is governed by specific standards under Article 3, I believe, of the ordinance. And I don't want to get too wrapped up in what is enforcement.
Article 4, Section
Sorry,
6,
thank
if
you.
the CEO finds any provisions being violated, can send notice, et cetera.
Correct. But I don't want to get too wrapped up in this notion of this as being enforcement. It is in a way, but it's actually worse than enforcement because it's not providing an opportunity to go in front of a judge, make your case with rules of evidence,
But is
and it's not
it
providing objective
significant
standards.
that the condition says this would have to be addressed at a duly noticed public hearing? So there'd be due process opportunity for your client to step in and say, well, you claim that there's been a significant adverse impact which was not anticipated at the outset, and to litigate it there. It isn't like the town can unilaterally yank this. Rather, it must come back before the board. Does that make any difference in the big picture?
It makes a huge difference. It's a lay board. They're applying a very subjective standard that is impossible to figure out what you're supposed to do to avoid adverse impacts. It's unclear whether, if a subdivision is built next door in the intervening 20 years, does
But
that
once
come
the
into play?
permit is granted, though, does that mean that that the successful applicant owns this right, that nobody can address it after the fact other than in an enforcement action?
Absolutely.
Is it a vested right?
It should be a vested right. The problem here is this circular thing of they never get a vested right because it's always going to be open.
But if it didn't have this bailout clause in there, is that a vested right?
Yes, absolutely. And that's the whole idea of municipal permitting. Things may change around you, but you have your vested right.
Well, let me ask you a remedy question.
Yes.
This might be a Pyrrhic victory in that, let's say we agree with you. We would then send it back to the board, who would then say, we thought that this many trucks and this time was good enough because we could go back and check. If it wasn't, we better half the number of trucks and half the number of this if we have to be firm about this without a reopener. Would you be happy with that?
No, and I don't think that that's the remedy. I think the court could just simply nullify these conditions because they're invalid. And if you look at the planning board's actual findings, and they're extensive.
But when the conditional use permit has conditions on it, don't we have to assume that they were considered as a whole? In other words, that the permit was granted if you do A, B, C, and D. And if we said, well, D's no good, don't we have to send it back to say, well, it would be good enough if you do A, B, and C or not? Because that's not what their determination was.
No, because the planning board here actually was thinking about the future when it made those specific restrictions. So it said that the operating hours are, quote, unlikely to present significant adverse impact.
So
and
what
it said
does
the 70 truck
in
trip.
this case say?
Sorry, what's that?
What does the mandate say?
If we go your way.
Go your way,
how
what
do-
does the mandate
Draft
say?
it for us.
happily. The mandate would say that because the planning board only had jurisdiction to apply this standard at the time of approval, the conditions that attempted to take jurisdiction in perpetuity are invalid.
So the permit stands with the strikeout of the language you don't like?
Correct, because the planning board already considered all the evidence before it and determined that that 70 truck trip limit was unlikely to present adverse impact and that it addressed the quote
But we
potential
can't
impact.
substitute our judgment for the board. So we can't be sure that if the board knew that it wouldn't be allowed to have a reopener, it would have ruled in a different way based on the public's concerns and its own familiarity with the town upon which it is allowed to rely.
Well, again, the findings show that based on the evidence that it had in front of it and all the concerns that people had put in, the 2 people who commented, about the potential, they used those words, the potential of truck traffic was dealt with in the conditions that applied, which, by the way, apply to the much larger operation right next door without a reopener.
Well, let me ask you this on the same question then. I mean, they've done, the 2 conditions that the reopener is attached to is the number of the hours of operation and the truck, the number of trips by the truck. If for whatever reason on appeal, if you were appealing those substantive conditions and we said, oh, you can't talk about the number of truck trips, and you're saying we could let it stand simply with hours of operation regardless of the amount of truck trips? I mean, how are those not part and parcel that they get to decide, well, if that condition doesn't stand, here are some other conditions that we might think would help?
I think the very standard expected types of conditions that these are, hours of operations, that's one that's specifically listed in the powers for conditional, or for conditions that could be put on, and the operating hours, very specific, very discrete, taken together. The board had done this before with this application.
Right, but if we
and
eliminated one of them, wouldn't they have the right to revisit whether there were other conditions they would feel like they needed to impose, or whether it was sufficient to just have one of those 2 conditions?
I mean, it's a hypothetical question, but the thing is they are being left in place together to address this issue of adverse impact through truck trips
I
and all
understand
of
it was a
that.
hypothetical question.
So you'd
That's-
keep them, but you would keep them together. The 70 truck trips, the hours of operations, those stand. All you're doing is taking away that jurisdiction to retake and to pull the rug out from the
We
applicant
can't
in the
assume
future.
that the board would have approved the permit without those conditions, can we?
I think we can from the very language of the findings, which say that based on everything that was in front of them, they find these restrictions sufficient.
Thank you, counsel. I know you reserved some time for rebuttal. And Attorney Plant, we'd be happy to hear your arguments.
Thank you, Your Honor. May it please the court. The legal issue before the court in this case is not novel. In fact, it is well established that reopener conditions are consistent with Maine law. 20 years ago in S.D. Warren v. Board of Environmental Protection, this court found that the BEP possessed the authority to impose reopener conditions on a Clean Water Act certification. The DEP also has statutory authority to attach reopener conditions to waste discharges, licenses, excuse me. So it is now commonplace for reopener conditions to be attached to certain state environmental permits. In this case, the planning board imposed conditions that the state commonly does. The planning board found that the imposition of the reopener conditions in question was necessary, and that is a direct quote from the board's decision, in order for Newfield Sand to meet one of the approval standards that applied to this project. I'll acknowledge that reopener conditions likely aren't appropriate to attach to the approval of every type of use, but reopener conditions are appropriate to attach to disruptive extractive uses that pose inherent risk to the health of the environment and local communities. So in the Clean Water Act context, discharges into navigable waters are a heavily regulated use because of the risk that that activity poses. In the analogous context of municipal conditional uses, and in particular mineral extraction is heavily regulated because of the risks it poses to the environment, to groundwater, to the local community, and so on. So reopener conditions are an appropriate regulatory tool to ensure that heavy extractive industries, such as mineral extraction, continue to meet permitting standards post-approval. The reopener conditions in this case are intended to function as that, precisely that type of regulatory control and nothing more. I see that the green light is not yet on, but I am happy to take the court's questions.
Okay. First, is there anywhere in the ordinance that the planning board has allocated the power to revisit the grant of a conditional permit, or to revisit the conditions to have a reopener, any of those things?
Well, Your Honor, there isn't, but this court has said in S.D. Warren that there doesn't have to be. There is a broad grant of authority within the ordinance to attach conditions to conditional use approvals.
But we've also said that once a permit, once somebody complies with all of the terms and requirements and is granted a permit and engages in substantial steps towards building or doing the activity, that cannot then be revoked because it becomes a vested right under SAL, under NECEC.
Well, this isn't a vested rights issue, because the rights that vest in a permit. Well, the rights that vest in a permit are dictated by the permit itself, and if the right is conditional in some sense, then that is the extent of the right.
Let me get back to the issue. You keep citing on S.D. Warren and saying it's well established. And we have to start from the premise that it's got to be in the ordinance for them to be able to do it. And it is different, qualitatively different from the other substantive conditions. So you would expect there'd be a licensing scheme, or there would be some language there explicitly giving them the power to do this, wouldn't you?
I don't necessarily agree with that, Your Honor, and I think the regulatory regime that was at issue in S.D. Warren is instructive.
Well, it was an operational permit. Here what we've got is a land use kind of zoning decision. This goes on until the end of time. So it's like granting a variance and then saying, but we can change our mind at any time. Do you think they'd be able to do that?
Well, Your Honor, I think that's a different circumstance, and I mean,
well, how different? That's what we're trying to find out.
Well, I think one thing that I want to focus the court on is the record and sort of the nature of the imposition of this condition. I mean, essentially what the planning board found was that these conditions were necessary, a necessary measure in order for Newfield Sand to meet its burden.
Counsel, didn't the board specifically find that the mineral extraction, I'm reading from the decision, will not have significant adverse effects or impacts on the value or quiet possession surrounding the properties? Based on that finding, they set forth two very specific conditions. Now, what is going to change?
Well,
What's going to change in the future that would allow the board to kind of go back and reevaluate the conditions that they've already found satisfy that standard?
Well, I would disagree to some extent, Justice Douglas. If you look a little further down in the decision on appendix page 39, what the board said is, in order to make this finding, the finding that you referenced above, the board has imposed several conditions of approval. And then the board went on to say it finds the imposition of conditions 2 and 3 in toto necessary to find that the intensity of the applicant's proposed use will not have.
But again, they've already determined that as of the date of this hearing, certain conditions were appropriate, certain numerical limits on the time and on the number of trucks. If that's true today, or at the time of this hearing, what is it in the future that's going to make that suddenly unacceptable or contrary to their finding?
Well, I think the way the court should look at these conditions is the board found that those limitations were appropriate, provided that it could reopen and
I
reconsider
understand,
those things.
but from your perspective, what would change?
Well, you know, I think it's important to note that this particular land use approval has been subject to a reopener condition for 30 years. And as far as we know, that has not ever been invoked.
So are you saying that they're stopped from arguing about it?
Well, Your Honor, the way that I look at the issue is you purchase a property that's subject to a land use approval, and you continue to operate pursuant to the terms of that land use approval, and you're subject to the conditions. You can't buy a property and then challenge aspects of the land use approval you don't
But this is a new
want.
permit. I mean, this is a new conditional use, correct?
This is an expansion of an existing conditional
And with
use.
all new conditions, I mean, I realize some of them are similar, but nonetheless, nobody was suggesting you couldn't impose entirely different conditions, right?
Well, Your Honor, I mean, I think if the planning board had simply imposed a condition saying all previous conditions carry forward to the expanded operation, we might potentially not be here. And I mean, isn't that often what happens in state environmental?
Or
If I can take you back to Justice Douglas's question, the two sections here, 2 and 3, relate to hours of operation and truck limitations. That existed at the time, as he pointed out, and he asked you what could change in the meantime, and I didn't really hear what would change. So what's really happened here is the board here has said to itself, if we decide at a later point that maybe that wasn't the right decision, we can just go ahead and kick the thing open again. There's no change of condition in here that would trigger that, except the CEO coming in and saying, oh boy, this 70 trucks a day and the days of operation, it's not really good. We shouldn't have granted this thing in the first place. See what I'm saying? They've just opened the door to start the whole thing over at their own behest.
And if I could just piggyback on that question, if you could answer both. Are there any limits in your mind to what the board could do upon reopening? Could it reduce it from 70 to 35 trucks a day or 5 trucks a day?
I'll try and take those questions in turn. First, I mean, I think, again, it's important to note what evidence the board actually did have in front of it. The only evidence regarding the impacts of traffic was, safety-related concerns with respect to increases associated with Newfield Sands truck traffic and local roads, children's playing on them, so on and so forth. And there wasn't any sort of traffic impact study addressing, what Newfield Sands prospective trucking impacts will be on the community. The only thing the planning board had to go off in this instance was this public testimony.
But if they didn't, I didn't mean to interrupt you again, but if they didn't have enough information or evidence at the time, they had two options. One was to say, come back and show us traffic studies. But I think what they can't do is to say, well, we'll go ahead and issue it. But if it turns out that it wasn't a good idea, we can go ahead and overrule it down the road.
Well, that isn't exactly what they've done. I mean, these conditions don't function as a means for the board to retroactively revoke its decision. I mean, they allow the board to amend two discrete operational aspects of this particular project. So it isn't a license for the board at some point in the future to entirely revoke this approval. And
it says they can reevaluate. That's a pretty powerful word.
Well, I mean, the board is always constrained by administrative law principles. It can't reach decisions that are arbitrary and capricious.
Does the permit indicate what size of trucks are allowed?
I mean, as I understand it, I think they're fairly standard
So
dump
if they
trucks.
suddenly just doubled the size of the trucks, would that be one of the things that might be a legitimate basis for a reopener if one were allowed?
And I mean, I do want to flag for the court that this is a protective standard. It's not significant adverse impacts. It's significant adverse impacts greater than those that would be anticipated by this type of use. So that standard accounts for the fact that mineral extraction...
That's a permitting standard, as the applicant points out. I mean, can a reopener be tied to a permitting standard as opposed to a performance standard?
Well, Your Honor, frankly, I think the distinction between approval and performance standards is an artificial one, and you need to read the ordinance in its totality, Article 8, Article 9, and the applicable standards within Article 10. And those provisions together dovetail and complement each other. There are specific provisions with respect to traffic impacts in Article 19, or excuse me, Section 19 of Article 9. And as Newfield Sand, or at least Newfield Sand, has taken the position that those are ongoing performance standards that continue to apply.
But does the ordinance differentiate between who has responsibility for enforcing the performance standards, right? The approval standards is the planning board. Who has responsibility under the ordinance for enforcing the performance standards?
It does, and I think the distinction between the planning board's authority and enforcement is a little bit of a red herring, because if the court agrees that the planning board has the authority to impose reopener conditions, then the planning board is the only authority that can change the permitting
But in a way, it's not a red herring, because what the planning board has done is it has tried to essentially deputize the code enforcement officer to do certain things. The code enforcement officer under Article 4, Section 6, if there are provisions, any provisions of the ordinance being violated, there's a process, and it goes to the Board of Selectmen. It doesn't go to the planning board. Under Article 7, if someone's aggrieved by a decision of the code enforcement officer, the appeal is to the Board of Appeals. How can the planning board, when it's not in the ordinance, sort of deputize and create, if you will, a whole nother function for the code enforcement officer that then reports to them?
Well, I disagree that it's deputization, because, for instance, I think of enforcement as, is Newfield Sand operating within its hours of operation? Is it staying below the established truck trip limits? And the code enforcement officer is arguably vested with the authority to monitor those types of things.
Yeah.
That's enforcement. And I mean, the code enforcement officer is best positioned to investigate complaints and things of that nature. That's not really the function of the planning board in this particular ordinance. It may be in others, but this sort of role that the code enforcement officer has to play in these conditions is entirely consistent with the authority vested in him in the ordinance.
But if he, does that mean that the code enforcement officer can go out and say, okay, less than 70 trucks, hours okay, but I think that this has had a significant adverse impact. Is that his call to make, to bring it back to the board?
Well, it's the board's call to make, right? I mean, if, again, what the code enforcement officer presumably would be looking at is the impacts this has had, and that would likely take the form of perhaps traffic accidents and a pattern that is disrupting the community more than you would anticipate from this type of use.
But
and it's up to the board to ultimately decide if the evidence
But
meets
he would get to
that
initiate the process that would create the reopening, right?
Which is protective, again, of Newfield Sand, because the planning board doesn't have any authority on its own to re-invoke these conditions.
In the few seconds that we have left, if we were to agree with the appellant in this case that condition, that the planning board did not have the authority to impose the reopener condition, what is the mandate?
The mandate is a remand, Your Honor, with instructions for the planning board to decide whether it can approve this project in the absence of these conditions or not.
Start from scratch?
Well, I don't know if it would necessarily be an instruction to start from scratch, but if the board, or excuse me, if the court disagrees that the planning board doesn't have the authority to impose these conditions, then the planning board can either change the operational limitations or it can issue a denial.
Thank you.
Thank you.
Attorney Collins, you wish to be heard in rebuttal.
The question was asked what in the future could change that might justify this reopener or bring it back up. It's always going to be an externality, as far as I can think of it. It's going to be a subdivision was built next door, or the population has increased, or the roads have become more.
What if you doubled the size of your trucks?
I suppose, but that potential was there in the beginning. They could have asked, they could have confirmed the size of the trucks and made that a condition of the approval, but didn't. The problem with these externalities is not only that Newfield Sand has no control over them, but that, you know, again, this idea of vested rights is to protect what we have in front of us today. And I gave the example in the brief of a subdivision. When we evaluate a subdivision as a planning board, we determine whether it's going to have undue impacts on municipal services. What if it turns out there are loads more kids in
Well,
that
there's a
subdivision?
qualitative difference between operations and kind of land use. I mean, this permit goes on forever, but it relates to operations. While, somebody builds a hotel and you go, wow, that was too high. You're not going to make them, take half of the size of the hotel off because that right is vested. But when it's an operation, you don't normally vest an operation, do you?
Take that hotel example. The hotel has the part where you pull in to unload bags, and the board determines that that's not going to impede traffic on the road. Then it turns out in the future that it might. So we're going to have a condition on it that says, even though you built the hotel that way and you're dependent on the people being able to build in or to come in that way, well, it's causing traffic problems, so you have to stop doing that, even though that changes.
Yes, but let's take a porn shop. There's no vested right in a porn shop. They can get rid of porn shops by saying, we've changed our minds. We don't want porn shops here anymore. And because you can exercise another use of that property, it's not vested, correct? It's operational.
Well, it's a non-conforming use at that point. I think the case law is quite clear that if that porn shop existed before and you say no more porn shops, they're non-conforming use. They have the right in their vested rights to continue running their business until they decide to stop.
So if they gave you a conditional permit for the porn shop, then you get to do it for the rest of eternity?
Absolutely. And with the porn shop example, an ordinance is usually going to have licensing that applies to that porn shop to make sure that it's operating and not causing nuisances. That's what's lacking here.
Thank you,
and-
counsel. I see that the red light is on. Thank you. And we will, as is our usual practice then, be taking this matter under advisement and issuing a written decision in due course. With that, we'll be in recess for lunch.